Any mention?
Lordship, I beg to mention item number 18.
Yes.
The matter may come up after 3 weeks, Lordship.
No objection, Your Lordship.
Okay.
2 weeks on the prayer of the petitioner. Yes.
Much obliged, Lordship. May please, Your Lordship. Your Lordship, I beg to make a mention of item number 22, Your Lordship. You have already informed the opposite party also, Your Lordship. I humbly pray kindly this matter may be listed after 2 weeks, Your Lordship.
Yes. It's all right.
All right.
Yes. Yes, 22. 2 weeks on the prayer of the petitioner. Yes.
Hello, Lordship.
May it please Your Lordship. Your Lordship, I beg to mention item number 23, Your Lordship.
Item number?
23, Your Lordship.
Yes.
Your Lordship, the convicted counsel, Mr. Yubin, is on sanction leave, Your Lordship. He's on leave, Your Lordship. Can you pray for 2 weeks' time, Your Lordship?
Let be after 3 weeks, Your Lordship.
Okay. 3 weeks on the prayer of the appellant. 23.
Oblige, Your
Yes,
Lordship.
Your Lordship.
Lordship, I beg to mention item number 11, Your Lordship. The conducting counsel for the appellant is on sanction leave, Your Lordship. So short date may be given.
This is a part-heard matter.
Lordship, yes.
This is what offence involved here?
And that is a POXO, Your Lordship. They'll come after 2 weeks, then, Your Lordship.
No, then we'll release it from part-heard then.
Lordship.
If possible, let it come on 11, Your Lordship. Wednesday.
I don't know what will be the situation on 11th.
They'll come after 2 weeks, Your Lordship.
We'll release it from part-heard. I'm as so-and-so, Lord Counsel, appeared before the appellant. Prayed for adjournment of the matter on the ground of non-availability of Mr. B. the Lord arguing counsel, appearing for the appellant. If we say in the beginning appellant, then second party is not appellant. The prayer has not been opposed by Mr. Shulai, and the AG. Stop. The prayer allowed. The prayer for adjournment allowed. The matter stands released from part-heard. List after
2 weeks, Your Lord. Apply, Your Lord.
Obliged, Lordship.
Your Lordship, I beg to mention item number 12, Your Lordship. We are praying for 2 weeks' time, Your Lordship. No objection, Lordship.
what is this matter about?
Lordship, this is a civil revision petition, Lordship. We had
What is the subject matter?
subject matter, Lordship. There's a dispute between two villages, Lordship.
Boundary dispute.
Boundary dispute.
Any interim order here?
No, Lordship.
Okay. Okay, on the prayer of the petitioner, not object to the Learning Council appearing the respondent. Release this matter after 2 weeks.
2 weeks' time, Lordship. Much obliged, Your Lordship. Highly obliged, Lordship.
May I please, Your Lordship, I beg to mention item number 13. Pray for 2 weeks' time.
13 and 14 are, Lordship, arising out of the same Lokayukta order.
You are appearing for?
The petitioner in item 13, Lordship.
And in 14?
14, the state has filed the petition against the Lokayukta.
13 and 14. In
Essentially the same order.
So if one is urgent, the other also will be urgent.
Actually, because the same order under challenge, Lordship.
I'm the respondent, Lordship. No objection, Lordship.
Yes, on the prayer of the petitioner, not object to the Learning Council. The respondent. List after?
After 2 weeks. 2 weeks.
For another adjournment. List after 2 weeks. Yes. And that is what is happening here. See, we're gaining nothing only except making this order sheet thicker.
Stay is granted since 2021, so
It's remaining like this.
I have no objection.
Yes.
Lordship, please, Lordship, this item number 16 and 17 also is a local matter, but I pray Lordship.
I am appearing in
also
item number
maybe
17 for the petitioner.
Time to
Lordship,
accommodate
the matter is for hearing on the impediment.
16 and 17, Lordship.
You are
Yeah,
appealing for?
I'm for the respondent actually, proper private respondent.
Lordship, I am for the petitioner in item 17. Mr.
You
P.T.
go that
Sharma
side.
has filed an
You are, yes, yes, Dr. Agarwal. Yes.
Lordship, in item 17, 16 and 17 are connected. It's against the same order that we have filed the writ petition criminal. And Mr. P.T. Sharma has filed an impediment application for impediment of the secretary and chairman of Lokayukta.
Yes.
So the impediment application is yet to be heard.
Let it come together, Lordship, because
Together means first you have to hear the implement, then only the question of this.
I need to bring some judgment, Your Lordship.
Okay, then you just both the writ petition and just one prayer made by Mr. P.T. Sharma, learned counsel appearing for the respond number.
2, my lord.
And so,
2.
Come on, not objected to the learned counsel appearing with the petition. This is matter
After 2 weeks, Lordship.
16, 17 both are same.
Lordship.
After 2 weeks.
Lordship.
Lordship.
Yes.
Obliged, lord.
Much obliged, Lordship.
Yes.
I beg to make a mention of item 20, my lord. For the state respondents.
Who is the other side?
So this is also connected with 19. These are quashing petitions.
Lordship, I am appearing for the state respondents in item number 19.
Okay.
Praying for some time, my lord.
So these are connected matters.
Connected matters.
1920, same FIR.
Yes, madam.
Quashing of the same. There are 2
Investigation has been
FIRs.
stated.
In fact, my lord, there are 3 writ petitions pending before this. Criminal petitions, my lord.
3 criminal petitions.
My lord.
Where
2
is the
criminal
other one?
petitions.
The other one
That
is
is on 9.
Anu Jain Bora, my lord. That's probably listed on 8, my lords.
Challenging the same FIR.
If I may just explain, Lordship, there is a dispute between 2 private parties. Now, the petitioners here in 19 and 20, they are the officers of District Council, Garhwal District Council. And they have also been booked under the same FIR as well as a suo motu FIR lodged by the police, saying that basic allegation is they have manipulated the records.
So in all 3 cases,
My lord, on the basis of the FIR, they've been
Yes.
arrested.
so not a suo motu FIR.
There's a suo motu FIR after the first FIR. Investigation has been stayed.
Confusing me thing. Anyway, you see, the mentioning thing we cannot decide on that. Then,
I have no objection because here also protection is granted.
okay. Just say on
19 and 20.
19. And then 20?
19 are for the state.
I made a mention for 20, my lords, but since these are analogous matters, my lord.
No, you are appearing in 20.
My lords.
And then 19?
19.
I am appearing, Lordship, for the state.
So the 19 should be adjourned on whose request? 20 is a prayer on the state.
Lords.
State respondents. And the 19? Yes.
19 laws, we were prepared for the matter. In fact, since 2023, a stay is there.
So
In
then,
item number 19, a stay was not granted, but in 20, it was granted, so it's extending to both the matters.
so what is to be done? Then we'll take up the 19.
As your Lordship please.
Then that 20 also let it
But,
remain in the list.
ultimately, the state will be the same, Lordship, because both are GHADC officials and Official Secrets Act has also been invoked in the suo motu FIR.
Yes, because otherwise you see, like it seems
Only prayer is
that
Lordship,
these
which
two
has to be
matters are
taken
kept
up
together.
yes.
Okay.
Yes,
That
Lordship.
is what the problem is. You see, we cannot adjourn one matter and hear another.
Lordship.
So
Yes, Lordship,
if
that
19
is
is to
the-
be heard, the 20 also has to be heard. That is the main thing.
Yes, Lordship.
Or otherwise you have to separate it.
Yes.
Fast then. So that is what. So choice is yours. If you say you should go for hearing, then both the matters will go for hearing.
Lordship, it would be better if both the matters are heard together.
Yes. So then it will be heard together today. You are ready for that?
Lordship, I will not be in a position to argue on behalf of Madam Yangi. She is appearing in item number
Let
20.
it be
Okay, you
adjourned
are
on behalf
right.
of
You are
the state,
20.
Lordship.
Okay,
I don't see any
So
reason.
that is what. Then you should not say. Then you say if it's okay.
Let the
then
matters
it is
come
both
out
the
in 2
matters.
weeks. Yes, my lords.
Both the matters, yes. That is what is needed actually, you see. If you have two different prayer by on behalf of the state, then it becomes difficult for the court.
My lord.
Just on these two matters, based on request made on behalf of the state respondents, this is met after 2 weeks.
Lordship.
Okay, 1920. Yes.
Obliged.
Obliged.
Yes,
May
Mr.
I
Ananda?
please, Your Lordship. Item number 21. The matter in the division bench yet to be decided, my lord.
3 weeks.
It's 3 weeks, Your Lordship.
Yes, 21, 3 weeks. Yes.
No, sir.
Supplementary cause list, item number 1.
Yes.
May it please, Your Lordship. This is an application under Article 227, supervisory jurisdiction. Milord.
What is wrong there?
Milord, here, Milord, the suit was filed in 2013, and today is 2025, Milord. Now, Milord, the subject matter of the suit is that the sale of the property which is located in Lashamya, sale of the property to the petitioner, that is under challenge in that. Primary only on the ground.
You are defendant in this suit. You are a defendant in the suit.
Yes, ma'am. In the main suit we are
That is
defendant.
what.
Similar, the thing is that the main ground on which the sale has been challenged is that there was an earlier suit between the plaintiff in that suit and the plaintiff in this second suit also, and
Wait. Second suit means?
this suit which we Milord, in this the case of the plaintiff is that there was an earlier suit in which there was an injunction against the seller as the defendant.
You are the seller.
I am the purchaser.
So you are also a defendant. Then
The seller is also a defendant. Main defendant is the seller.
what right plaintiff has there? How come plaintiff comes in between the seller and?
Milord, the plaintiff says that in the earlier he has filed a suit against the defendant number 1 in the second suit, that they had an agreement for sale.
Okay.
They had an agreement for sale, and then some consideration was paid, and therefore, in violation of that, and there was an injunction also preventing the seller from selling the thing. So, Milord, the primary ground taken in this second suit is that the sale would be a nullity because of Section 52 of the TP Act, that pendency of the sale, Milord. Now, Milord, here the question which we are raising is that in that area, in Lashamya area, Transfer of Property Act does not apply. So it is a legal issue primarily. Milord, because of this not being decided for long 12 years of time, Milord, the plaintiff, the petitioner here is being deprived completely from enjoying his bona fide rights as a owner. So we have come for quashing of the whole suit, Milord. Now, under Article 227, whether your lordships would quash or not, Milord, that is a settled position that your lordship may quash a suit also.
So your ground is delay, pendency, long pendency.
Long pendency, and the prayers.
That becomes a ground for quashing under 227.
My lord, and the prayers made in the suit, those are impossible to grant. Because, my lord, these do not,
No, but then
they
whether
do
it
not,
is
do
possible
not
or
enjoy
not,
the sanction of law.
that will be decided in the suit. We will not go into the merit of the thing.
Because my lord, my lord, that is my point.
227 is power of superintendence.
My lord.
When it can be invoked.
My lord, when the suit itself is, the reliefs claimed in the suit itself is impossible to be granted, my lord. is important.
That
Suit has become
that
in
question
future.
will be decided by the court where suit is granted.
That is what I'm saying.
Challenge the
That is what I'm saying. That is what I'm saying, my
Have you
lord.
filed, challenge the maintainability of the suit.
No, my lord, everything has been done, my lord, but no decision is being given for long 12 years, my lord. So, my lord, I would just respectfully submit, my lord. Notice may go, the matter may come up for admission, my lord. We may be allowed to take steps.
Because 227 is very unusual in suits, not to be exercised normally, until and unless there is a abuse of process of law.
Grave injustice.
Yes.
There is no interim prayer as such.
Lordship, state is the pro forma respondent herein. The main respondent would be the plaintiff in the suit, Lordship.
Yes.
Who are the party here?
Here the main party is the respondent, who is the
Respondent
plaintiff.
number one.
Respondent number one is the plaintiff, and the others are pro forma. State is the pro forma. Because they are pro forma in the suit also.
State? No, 2 and 3 they are performed.
They are 2 and 3 are pro forma.
Hard Mr. Dorothy, counsel. And a senior counsel assisted by. So just issue notice, returnable in 3 weeks. MS NG Shillan under senior G. APS for respondent number, performer respondent number. 2 and 3 they are performer, isn't it?
Lordship.
Performer respondent number 2 and 3.
They are represented.
Yes. The petitioner shall take steps for service of notice upon the respondent. Upon the respondent number 1 within 2 days.
Well, I may be permitted to take steps through the counsel on record in the plaint.
He may, counsel is no service. Counsel may refuse. So take by normal thing and then just let us see.
Apply, Lordship.
List of
Oblige.
cases. Yes.
Item number 2.
Before my learned senior begins. I'm sorry.
Just
Before my learned senior begins.
You are in a hurry, Mr. Paul.
No. Yes. I appear on caveat on behalf of respondent number 3.
Yes.
I had little difficulty. I've expressed to my learned senior as well. If my lords kindly accommodate us on Monday, if that's not inconvenient.
Yes. Is there any interim prayer here?
Here there is an interim prayer. My lord, it may come up on Monday. I mean, we have an interim prayer. Monday also interim can be. But there is another private respondent here, my lord.
Here also it's arising out of a suit.
No, my lord. This is quite a history. The matter
That airport matter,
connected to the airport matter.
Land compensation from the
airport matter, that PIL.
Connected to that. My lord, in that, my lord, when the land was acquired for the airport, my lord, 32 acres were taken from the army. And for compensating that 32 acres, the land was, an acquisition proceedings was held. So this is arising out of that acquisition proceedings. Acquisition proceedings were not.
Hope this court had no hand in there, because there were some cases where earlier.
We'll check that also,
Probably in this.
I don't think so, but we'll still check.
There was some enquiry to be conducted, and then.
My lords.
Yes, probably. That was.
We'll check that.
Inquiry was there.
Judge Nangpo or officers of Nangpo.
Yes.
May not be. I think that will go before some other bench.
Acha.
We're not aware. We can find out and get back to my lords on Monday. We'll run through the records.
It's up to you, but then you do not know if the court had directly or indirectly had any role. Then
we'll assist my lords. On Monday, we'll get back to your lords, my lords, with that details. If my lords have appeared in any way.
Mr. Shulai knows about that.
I think our lordship, yes.
Probably
might have a hand in the.
Yes, that is what.
Lordship
Yes,
was
it will go before other
AG at that time.
Let go on.
It will go. It will go.
It may come on.
List this matter before any other bench. Because that point of time, definitely on behalf of the state, probably this court.
My lords might have appeared.
On Monday, my lord?
Because since court remembers the fact, so.
I'm sure.
Mr. Khan was inquiry.
Yes, my lords, he was the first inquiry officer.
First inquiry officer.
Yes. Definitely, this court.
Some other bench.
Some other. It will go before some other bench.
It may come on Monday, my lord?
It will not come up in anything. Monday means if you say that it will be listed before some other bench, then.
It depends on the bench.
Just I think this will automatically go after on Monday. I think. Yes. It will go because it will go to before Chief Justice and then
for re-endorsement.
Obliged, Your Lordship.
Item number 3.
Yes.
May I please, Your Lordship? This is the matter for regularization of the service of the workers employee. Brief fact is that, my lord, initially the petitioner was appointed as a handyman, roller handyman, in 4/8/1991, my lord. Thereafter, he was
On casual basis.
Yes, my lord, as a workers employee. Subsequently, he was promoted to the post of sectional assistant, workers sectional assistant, in 4/8/1999, my lord.
Work charge appointment, then work charge promotion.
Yes. They have mentioned like that,
Yes.
my lord. Thereafter, my lord, he is continuing in service, my lord, and getting his increment. Suddenly, his increment was stopped in 2017 due to non-approval or non-regularization of his service, my lord. So, in this regard, my lord, there is a number of circulars. One circular is 24/11/2000. Those who are appointed prior to 27/10/1997 of workers employee, their service should be regularized, my lord.
That has come, I think, pursuant to Umadevi's judgment.
Yes, my lord. Yes. Then I am coming to this.
There is a scheme, isn't it, of 1996?
Yes.
Regularization of work charge employees.
Yes, my lord.
Isn't it?
Yes.
Now, your regularization has to be on the basis of that scheme.
Yes.
Is it not that, madam, that is...
Yes. As per this order which my friend has just mentioned, as on 1993, Your Lordship, he should have completed 5 years of service as a work-charged employee.
In 1993?
Yeah, as on 93. But he had joined service only in 1991 as a work-charged handyman, Your Lordship.
But then thereafter, I think...
There is-
a scheme of 1996 scheme is there.
1996 scheme, Your Lordship will have to examine that, Your Lordship.
No,
Probably it may be there, maybe Miss Colony can say. There is to be a number of cases basing on that claiming
That is
regularization.
muster roll workers, yes, Your Lordship. I'm aware of that muster roll workers 1996, but I am not sure about work charged employees.
That 1996 scheme is
muster roll workers.
Only it concerning only
muster roll.
Only muster roll.
Oh.
Not
work charged employees.
Now I am coming to the annexer. Annexers 10, my lord, page number 37. Type copy is page number 40, my lord. That matter will be...
Page number 14?
40, my lord. The matter will be clear, my lord.
Page 14?
40,
40?
40, my lord.
40?
Yes, my lord. Yes. This is the type copy.
Yes.
Yes. Then this Under Secretary to the Government of Meghalaya, PWD Road and Building, written a letter to the Chief Engineer PWD Road and PWD Building, my lord. Here, my lord, I am giving subject regularization of workers employees.
Yes.
With reference to your office letter on the subject cited above, I am directed to say that the government in personnel ARB department agreed to proposal for regularization of the workers employees appointed prior to 27/10/1997 as the lease enclosed herewith at Annex 1, subject to condition that the constituent vacancies in the workers establishment would stand lapse and no new appointment in the said vacancy should be made, my lord. Now I am coming to the list, my lord. Page number 42, my lord.
Yes.
42, my lord.
Yes.
Yes. The post of serial number 1, my serial number is 2, and serial number 3. Their post is already been regularized, my lord.
You are number 2.
I am number 2, my lord. My
Nongpo
one is left out.
Nongpo division, isn't it?
Yes, my lord. Nongpo division. Then I am coming to the annexer 11, page number 44, my lord. My service was regularized, but Deputy Chief Engineer PWD wrote, written by the executive engineers, subject regularization service, clarification thereof. Sir, with reference to the subject cited above, I have the honor to clarify regarding the regularization of service in favor of Anas Kim Land Khonghat that, sir, as per record available, the person concerned joined his division as works as roller handyman in the year 7/4/1990, for which his regularization has been done. White letter such and such dated 24 November 2000, my lord.
Say like your regularization was done prior to
No,
the
no, no,
issuance.
yes.
Then
I'm coming, my lord. Copy and close. The upgradation works are sectional assistant joined on 5/8/99 and regularization for this post of sectional assistant done white letter number 31st January 2020, my lord. This regularization they have done, my lord, without the approval of the personnel department, my lord.
now one thing you fail to understand. Just see.
Yes, my lord.
Loophole in the communication. Now it says that you have been regularized by a communication dated 24th November 2000. Isn't it?
Yes, my lord.
And then upgraded to assistant and joined on 1999.
Yes, my
So
lord.
how can that be there? That means that your regularization has been, the upgradation is not prior to regularization. It's
No, upgradation is 99.
See the language.
Then regularize. No, my lord. It is some confusion. Join on 5/8/99. Regularization for this post of sectional assistant done on 31st January 2020, my lord.
still remains the confusion. You see, then upgraded to what just a sectional joined on 5/8/1999. So that means you joined as worked as sectional assistant prior to your regularization
Yes.
by the 24th November 2000,
Yes.
isn't it?
Yes.
So there is a confusion there.
Yes. 20 they have regularized.
Anyway, what is the cause of action now?
Now, cause of action, my lord, my simple prayer, there is, I have enclosed two writ petition, my lord, which is squarely covered my case, my lord.
What is your grievance here first? Then the question
My
of-
grievance is that my service should be regularized.
that is already regularized. That is what
No,
they
no, no,
say.
my lord. I am coming to the next page, my lord.
Yes, so show us. Where is the
Yes,
controversy?
then annexure 12, my lord.
Yes.
With reference to the subject cited above, I am enclosing here the government letter dated 31st April, which is self-explanatory, along with the list of works assembly under your division, and to request you to take necessary action as per government instruction contained therein. Then what happened, my lord? Then I am coming to another page, my lord. It is in page number 23, my lord, 23. Type copy is 26, my lord.
Yes, this is a communication of 2009, page 23.
26, my lord.
Yes, 2016.
Yes, my lord. With reference to the subject cited above, action cannot be taken as the incumbent IPS initial pay statement of 2007 was unapproved. Copy and close reference. This is for because my
that is a departmental.
No, my lord. It is coming to that. That means my post was not approved, given the approval from the personnel and administrative reform P department, my lord. Without their approval, they have approved.
So it means you want to say that 2016 communication is a bearing on the 2024 communication.
No.
The communication at page 43
Yes,
is
no,
2024.
it is not just giving the reference.
We have not understood your cause of action, real cause of action.
No.
Yes, madam, tell us what is the...
Lordship, from the...
This court has not really understood what the grievance is.
There is some confusion, Your Lordship. This gentleman, the petitioner, was appointed as a work charged employee in 1991, Your Lordship. Now, Your Lordship, in 1999, they claim to have been upgraded as a work charged sectional assistant, Your Lordship. Now, in 2000, Your Lordship, that is in November 2020, there is a letter which shows that all work charged employees who had completed 5 years of service as in 1993 would be regularized, Your Lordship. But as he was appointed in 91, Your Lordship, he had not completed 5 years of service. Then there is a letter which is annexed as annexure 2, Your Lordship, at page 17, where the administrative officer, PWD Roads, Meghalaya, Shillong, has called for a clarification as to how this gentleman was upgraded as a sectional assistant on 5/8/1999. So, Your Lordship, there seems to be some confusion because he had not been regularized when he was upgraded.
We understand, but then what about this communication of 2024? Which is at
That
page
is
43 and
what
44. Anyway, you take instructions.
We'll have to
Just
take instructions
See,
on
this
this.
is if these facts are not made clear, then court has difficulty in understanding.
Yes, Your Lordship. So let
You see,
us.
the proper sequence has to be maintained. That is the problem. Now, here the
Well,
Land
his
Council,
grievances, his increment
Land
has not
Council is
been-
referring to some communication of 2024, which apparently in his favor. But then again, referring to 2016 communication,
It says
which
that how
according
he
to
was
him is
upgraded.
causing. Any hard, Mr. Hazarika?
His grievances has not received increment from 2017.
And regularization.
That is one thing, of course. But then he's saying regularization.
Regularization
And regularization, how much court can do? That also remains a question. Hard, Mr. Hazarika, should notice. Same thing, 3 weeks. You will appear for all the respondents.
Yes, Your Lordship.
Yes. MS T. Angelana DAG, along with Ms. R. Corny Randy G. Appears for all the respondents. Hence, no formal notices. And hence, no formal notice is called for. Stop. The branded government council shall obtain necessary instruction before the next list after 3 weeks. Yes.
Also.
Item number 4.
May I please, Your Lordship?
Yes.
This is a pension matter, Your Lordship, similar to writ petition 357, which have already been placed before Your Lordship last week, Your Lordship.
I'll seek instructions, man.
How many?
3 weeks.
How many cases are there like there?
We know.
Only one respondent, isn't it?
Sole
Yes,
respondent.
sole
Follow the
respondent.
same. Yes.
Most like
3 weeks.
3 weeks, man.
Now, main list hearing has reached. Main list hearing has reached. Only one hearing. No, then first come to the order that supplementary. Supplementary. That yesterday's part had matter.
Item number 5.
Yes, the unfinished hearing of Dr. Mojika.
May it
In-
please, Your Lordship.
Yes.
Lordship, I just have a small submission to make in this. Your Lordship, yesterday we would like to file our comprehensive charge sheet, Your Lordship, by way of an affidavit. If Your Lordship, we are just seeking your permission for that.
See, we do not know. We are running out of time. That is the main
I
problem.
understand, Your Lordship, but we'll try to do it by tomorrow, Your Lordship.
I don't know, Lordship, what comprehensive charge sheet, what is
Because
before the
the-
trial court supplied to the accused, that is the charge sheet before the court, Lordship. Now they cannot add into it or
We
remove
have not
something out
added.
of it.
This was the charge sheet we received. But when they filed the charge sheet, we were under the impression that the entire bundle of papers were there with the
What is
on
filed
record.
before the
But
trial court has
yesterday
to be
we
looked
saw while at the time of arguing, we find that the BSF statements, personal statements, were not there, Your Lordship, in the charge sheet. Let us bring it on record,
That is
Your
what has
Lordship.
Now
been
if
forwarded
they,
to the
if they
court.
change the charge sheet per se, then the entire argument.
Anyway, let them. If they want to these things,
We have to
then
be-
we'll have
yes.
this matter on Monday. Then you
On
file it by
Monday, Your
tomorrow.
Lordship.
Monday we'll have it.
And Your Lordship, as I submitted, yes, Your Lordship, that if they overstay,
But then
then
the
Your
thing is
Lordship
that
can
after
always
hearing, court may also take time for passing
the order.
That
Your
is the main
Lordship.
problem.
I understand, Your Lordship. But court has the authority, Your Lordship, to direct the competent authority to extend the visa. since they are facing criminal yes, Your Lord. I've got an authority. Delhi High Court matter.
Monday is what date?
8th.
And when it is your last thing?
11th, Your Lordship.
Very difficult then.
I know, it's very tight.
So now if they want
Because we learned
to
only
supplement the
yesterday
charge
that-
sheet or something, then
We are not supplementing.
Let us see, let her bring on record, let us see. Just come with law, just see to what extent. If they, see, we cannot deprive them from filing.
Absolutely.
If according to them that there is a different charge sheet, then it must be brought into it. Yes, yes. Yes, Dr. Mojika, you will complete your argument only after, because as per Madam Yankee, there is a different charge sheet, so which requires to be brought into record. Yes. Just say M.S.T. Yankee, learned AG. Appearing for the state respondent submits that the charge sheet brought into record by the petitioner by UF an additional affidavit is not the complete charge sheet. Stop. According to her, there is a different charge sheet other than what has been brought into record. There exists a different charge sheet other than what has been brought into record.
Which we have received, Your Lordship.
Which requires to be brought in. What is it? There exists. Brought into record.
Exactly different. Charge sheet is the same, only the statements of the BSF personals were not included in the charge sheet which was filed by the petitioners, Your Lordship.
Then just cancel this line. What is the previous line? What is it?
Comprehensive charge sheet, that's it.
Okay, okay, stop, stop. She prays that the state may be allowed to bring to record the complete set of charge sheet by filing an affidavit.
Yes,
Prayer allowed. The charge sheet. The what do you say? But then it may not be a complete set of charge sheet also. Yes, say. Prayer allowed. The state is permitted to bring in charge sheet referred to.
It is but comprehensive which we received from the
Bring into the record the comprehensive charge sheet.
comprehensive.
By tomorrow, it will be possible tomorrow. It has to be done by tomorrow. Oh, just cancel that last line. You just say the state may do the needful to bring on record the charge sheet referred to in by the learned AG by tomorrow. That give the date. List this matter. Then give Monday's date for further hearing.
Lunch.
5 and 6, Lordship.
6 is also same.
Same.
Yes.
Same also. List.
Daily list, item number 1.
May I please, Lordship?
Yes.
As per the last order dated 28/2025, we have affected the dusty service. We will be filing the affidavit of service during the course of the day. Lordship. Yes, for respondent number 6. Okay. Yes, receive.
Mr. P.T. Sangwal, Learned Counsel submits that the respondent number 6 has been served by dusty service and prays for grant of some time for bringing on record proof of such service by UF and affidavit.
Lordship.
Prayer alert. When? List
After 2 weeks, he can come.
List after 2 weeks. Yes.
Item number 2.
Much blessed, Lordship. This Lordship, in this, what I am reporter responded.
Wait. Let the file come.
Lordship.
Yes.
I'm asking, praying for some time to file my.
Who is for the
objection.
petitioner?
Because
Nobody is for the petitioner. Yes, Mr. Ranger, you are for?
My lord, I have for respondent number 1 to 4, my lord.
Okay. And you will be there for respondent number 5. Respondent number 6. The petitioner is absent. And what is the
They are coming for questioning of the FIR.
FIR in what offence?
The FIR basically, actually, I filed the FIR.
What is the offence involved? Just say.
The offence is theft, Lordship.
Theft.
Yep.
So you are ready to
Right.
compromise?
Not compromise, but I'm filing the objection because case has been
so you are not
registered.
ready to compromise?
They have filed even charge sheet also.
You are not ready to compromise?
No, Lordship.
Okay. And then you are why your investigating officer has been implemented by name? Yes, Mr. Sinkon, you will be for?
I'm appealing for 1 to 4, my lord.
Okay. Mr. Ranger is there with
1 to 4.
Okay, just a none appears for the petitioner. So, as prayed for by Mr. P.T. Sangma, London Council, appearing for the respondent number 6. How much? 2 weeks?
3 weeks, my lord.
3 weeks time is granted
Lordship.
for filing objection.
Much less, Lordship.
Item number 3.
Lordship, pursuant to previous order, Lordship, an affidavit has been filed.
What is the status?
The status is that, Lordship,
They have been served.
So it has been delivered.
3 and 4.
3 and
no
4.
appearance.
So far, no.
You will be for this statement.
1 and 2.
And what is the matter here?
Lordship, delay in concluding the investigation is involving a 302 matter, Lordship, IPC. The petitioner herein is a government employee, Lordship. She is a government employee and she had been arrested and now she is suspended for more than 3 years. So there is no progress in the matter and so we have
Any timeline set by law?
Timeline not for this type of matters, but the adverse effect is there upon the petitioner, Lordship. And the investigating authority has got enough chance, sufficient time to.
Who is the respondent number 4 and 5 here?
4 is a private respondent number. Number 3 is
what
the
for
I.
they have been implemented?
Lordship, the number 4 had filed a missing report. That is number 4 respondent.
Number 4 is the
had-
complainant.
Informant.
Okay. Informant.
Informant.
And who is 5?
Number 4, 5 is no. 1, 2, 3, and 4 is there.
Okay.
So 1 and 2 is
3 and 4. Okay. So
Yes.
we are awaiting for appearance of 3 and 4.
3 and 4. 3 is the IO.
Okay. 3 is the IO.
IO,
IO is by name.
By name, Lordship.
Yes, Mr. Gurung, you will appear for IO or not?
My lord, I'll appear.
He is by name. He is by. You will appear for that. So only 4 is required.
Oh yes, Lordship.
So you filed an
So,
affidavit.
affidavit has been filed. So, the affidavit, I will draw your Lordship's attention to page number 14. Page number 13
Why
is the
such a
postal
big
receipt.
affidavit for?
Because 2 for the respondent number 3 and 4 both.
Okay.
So
Where is
page
the
number
four?
13
Yes.
is the postal receipt with the type copies at
Where is the,
page.
just show us the service report.
Lordship, it is at page 15. 16 at the bottom, item delivered,
Oh, you have just filed this affidavit based on the tracking details.
tracking
You have
detail.
to obtain a certificate. Certificate of service from the postal authority.
That I will do, Lordship. I will
Okay.
obtain it. But as far as number 3, Mr.
Yes, we'll
Guru
just
would
say.
appear.
We'll just say.
For 4, respondent number 4, I will
Okay.
obtain a certificate.
We'll just say. We'll just say Mr. Guru Leonard G. appearing for respondent number 2 and 3 submits that he has. He will also represent the respondent number 3 in the present matter. However, there is no appearance on behalf of the respondent number 4. The affidavit of service filed by the petitioner is not supported by proper document. Stop. Give a paragraph as prayed for with the learned counsel. As prayed for, the petitioner is allowed to file a fresh services affidavit in respect of respondent number 4 after obtaining proper proof of service.
Lordship may also grant me alternative mode of justice service also.
No, you can obtain certificate.
I will obtain.
If you say the tracking detail shows,
yes,
it is nothing. You have to, of course, the court is not there to approach, but then advise you, which is a very simple thing. You
simple,
just
yes,
write one
Lordship.
application,
Have to be approached to the superintendent of post.
It's very common. It's common practice. Ask
Yes,
the lawyer.
yes, I am aware of it.
So do it.
Okay. Item number 4.
Your Lordship, I have received the copy of the counter affidavit filed by the respondent number 5.
Yes.
I think it is not reached to the court, Lordship. I have received today. So when we fix on the next day, we can dispose of this is an admitted claim, Lordship, that this is a disability pension.
Okay.
For the son of the deceased pensioner.
Otherwise, the relief has been given to you.
No, Lordship, not yet, Lordship, because process.
It is in the process. So that should satisfy you.
That is why on the next day we will dispose it, Lordship, because that presence of the accountant.
So you receive a copy of the affidavit of opposition only
Yes,
today.
although I have received, most probably it had not reached to the court, Lordship.
That is okay, but then you have received the copy today.
On the
Give him
next
sometime.
Yes,
Yes. Yes, it is submitted by Miss M.S. Bhattacharya, learned GA. Where is the respondent number 5? Now they are here sometimes, they are not here sometimes. Okay. Just say
I have received the copy.
so and so is present, so and so is present, so and so. None appears for the respondent number 5. Okay. Then you just say it is submitted by the learned GA that affidavit of opposition on behalf of the state respondent has been filed. Stop. The learned counsel for the petitioner submits that a copy of the affidavit, a copy of the affidavit of the state has been supplied to him only today.
No, Lordship, so far as the state has already filed before, but a copy of respondent number 5, Lordship, Accountant General, Lordship, I have received today.
Oh, Accountant General has submitted?
Yes.
I have long time back, Your Lordship.
State has already
Just cancel this entire order. Just say such and such is present. None appears for the respondent number 5. It is submitted. The affidavit on respondent number 5 has already been filed. Come on, stop, Mr. Sheikh. Counsel for the petitioner submits.
I have received.
That he has received a copy of the affidavit of the respondent number 5
today,
only today, and requires some time to obtain necessary instructions. Prayer allowed. List after
2 weeks. 2 weeks. After 2 weeks, Your Lord.
Yes.
Item number 5.
This is also, Lordship, here on the previous date, government said that they are not going to file the affidavit. So I have received the legal heirship certificate, Lordship.
My Lord,
so
the only issue is the state has never objected, but then the petitioner was unable to, my Lord, establish a relation with the incumbent's pension. So now he has actually received it. So
I'll supply the copy to the respondent number 5, Lordship.
Wait. Just if you both of you talk together, it's become difficult.
Sorry.
Because the applicant, my Lord, was not.
What is the prayer in the writ petition?
My Lord, the pension, my Lord, pension of the deceased
you know
father.
the matter. So you start from anywhere, you will understand. The court will not understand.
My Lord, here
so this is a matter praying for release of
pension, my Lord.
Okay. Pension.
Yes, my Lord. Family pension, my Lord.
Family pension.
My Lord, yes. And the petitioner's name was not there in the nominee list of the PPO, my Lord. So thereafter, my Lord, they have approached the government. She is the daughter of the deceased, my lord.
No, I am the wife.
Oh, the wife, my lord. The daughter's name was in the PPO, my lord. So thereafter, my lord, the daughter is married. She has no issue with the mother receiving the pension, but subjected that she has established her relations, succession or legal aid certificates were demanded by the
Legal aid
accountant general, my
certificate.
lord. So which he has received, my
I have
lord.
received, Lordship.
So
I'll
they-
just.
So he can furnish to the
Yes,
the concerned department, my lord. He will receive it, my lord, because state has not objected to the relation, my lord.
So we can close the matter.
Lordship, I'll just give the copy to the accountant general.
They
Lordship.
can file it,
They
my
can
lord.
file a
They-
small affidavit after that because the respondent number 5 has not filed the.
Wait, this
That's number
state,
5.
state has done the necessary forwarding. Now it is part of the.
Yes, respondent number 5, Lordship. That is why I'll just communicate that that legal aid certificate to the respondent number 5. Accordingly, they can.
So there is no requirement of filing of affidavit by the state here.
No, my lord, there is no record because the PPO, it's my lord. Now he has my lord. The last annexion, my lord, is of 2025. The petition has already given a representation to the accountant general, my lord, regarding the release of the
It
pension.
means the state has performed all its duties.
Yes,
my lord. Yes, we have.
What is only for the respondent number.
So they can file a fresh representation submitting the documents, my lord. They should
To the respondent number 6,
my
not
lord.
to you.
Yes,
Accountant
the accountant
general.
general, my lord.
Anyway, then
Then Lordship, that's why. In the meantime, I'll just.
you
furnish.
verify. Then we'll just adjourn it. To the
Yes.
6. Okay. Just record presence. None APS for the respondent number 6. Yes, one prayer made by Mr. Sheikh, landed counsel for the petitioner. This matter after 1 week or 2 weeks. 1 week.
2 weeks, Lordship.
2 weeks. Yes.
Item number 6.
Yeah,
Status final.
1 week.
Yes.
May please Lordship, this matter can be closed because the prayer of the petitioner is only because just to reconstruct the service book and to complete all the formalities and release the pension and other service benefit. Now in the affidavit they have come up, they have reconstructed the service book of the date said it is for one they have clearly mentioned they have reconstructed the service book and then nothing remained. Now what I'm praying is that let them complete the formalities and then the service benefit whatever is there may be released to the petitioner.
Okay. This is a petitioner's own pension. It's
Yes,
not a,
this
not a claim for
own pension because they are not able to release.
Okay.
Just
Halt. Learned counsel for the parties. Staff Mr. P.T. Sangma, learned counsel for the petitioner submits that the writ petition has been filed, praying for a reconstruction of service book of the petitioner and also for disbursal of retirement benefit to the petitioner. It is also submitted by the Learned Council that the state respondent number 1 to 4 has already filed their affidavit of opposition, wherein it has been stated that
reconstructed
the service book of the petitioner has been
reconstructed the service book.
reconstructed
Yes.
and
Yes.
the steps for
Yes.
release of retirement benefit of the petitioner would be proceeded.
Yes. They don't say proceeded, but they have reconstructed. Now I'm praying that
Reconstruct and send it to the government.
yes, to the government.
Just affidavit or we say it like just it is also the service book of the petitioner reconstructed and forwarded to the government.
Yes.
For necessary
Yes.
action.
For necessary action.
That statement is there, my lord, in page 3, point
Yes.
number Roman 2, my lord, clearly stated.
You don't go by that also, it's okay. Affidavit in opposition, page number 3, my lord. Roman 1 and 2. 1, 2 and 3.
Page affidavit in opposition.
Page 3, my lord.
This is on behalf of the respondent number 2, isn't it?
Yes.
Affidavit in opposition on.
They have filed for all the respondents.
Election Department.
What is this affidavit? Counter affidavit bringing into record the service book of the petitioner by respondent number 2.
Yes. Now.
What is that? What that is meant?
3 in.
We did not ask for service book. Did we?
No.
Then?
Or reconstructed. They have mentioned.
No, the service book has been reconstructed, my lord.
No, that is okay. But then what is this affidavit? What is the need of bringing this service book into the record?
Yes. Actually, they have enclosed it.
You are doing whatever you feel like.
My lord, my apologies, but this was not filed by me. Nevertheless, my lord.
Whoever files it, you should be vigilant if you are appearing in the matter. And para 3 is at page 2. It says nothing. That's save and accept those statements and these things.
No, my lord. Page 3, Roman 2I. Statement, my lord, page 3, Roman 2, 1 and 2.
It is para 9, and then they have given sub number 1, 2, 3,
Yes,
4.
you see this after para 7, isn't it? Para 7, Roman 3.
Yes, para 7,
Para 7,
9.
para 8, para 9, my lord.
Para 9, Roman 2 and 3, my lord. Para 9, Roman 2 and 3. They have stated.
What is it? What stating there? Reconstructed. Just a minute. Along with IPS of 1987, 1997, 2007, and 2017, and forwarded it to the election department for necessary approval. Isn't it?
Yes, lordship.
Stop. The learned counsel, SS submits that since the service of petitioner has been reconstructed, he does not have any grievance. He does not has any further grievance at this juncture. And prays that the writ petition may be closed.
Yes, lordship, I small prayer, lordship, maybe directed to complete formalities and may release some frame time may be given to release because
time frame
because they have already
you are agreeable
constructed
to that time frame.
Because I have already been retired long back because
It will be stated at the earliest, my lord. Time frame as such.
at least 1 month or 2 months like that because used to give because
That
I
may
have
be
been
difficult,
retired
my
long back 2005.
It may happen. See, we do not know. Since you have agreed for closure of this writ petition, but then we do not know. They may say that you do not have a claim for pension also.
No.
Do you know what may happen? You see, can you foresee what may happen?
No, we have. They
Can you
have.
foresee
They
it
have.
now?
They have in their affidavit also. They have stated that they have already in the para
Right.
3 Roman 3 also they have stated that they are processing.
Processing for what?
For payment of pension and other service benefit. See, they have written.
Where is that?
It is page 4. Romans they stated from that number same page on the lordship. It started from Roman 4. That in
There is
pursuance
no
to-
Roman 4 in page 4. Roman 4 in page
yes,
3.
there is a continuation of that. Lordship, it is stated that could not be submitted. It is also requested that in the same letter that Deputy Commissioner Election and Party may request to kindly approve the initial pay statement to enable the office to prepare the pension paper of Sri Linderson Bisangma at the alias so that pension and other service benefit due could be released at the alias. So they have.
At the earliest, my lord.
They have, no, yes, they have
Time
stated.
frame will be difficult.
They have admitted and they said that they're processing.
No, just before the last line, what he said? What is the thing? No, before that. You may, if I repeat something, you just, while typing, you just ignore that repetition, okay? You just say, it is also submitted that the affidavit of the state indicates that step has been taken by the state respondent. Step has been taken by the concerned department for preparation of pension papers of the petitioner. Stop. Then you say the learned counsel there. Okay. Just say stop. The learned counsel therefore submits that in view of the statement made in the affidavit of opposition, the petitioner would not like to press this application any further. Stop. He, however, submits that the writ petition may be disposed of with a direction to the respondents to prepare the pension papers of the petitioner within a specific period of time. In paragraph, just say Mr. Kapi Bhattacharya, Learned G appearing for the state respondent, does not object to the prayer made on behalf of the petitioner. Stop. He, however, submits that fixing a specific period of time is not called for, as the department has already started the process for the preparation of pension papers of the petitioner. Stop. He submits that the pension papers would be prepared. He submits. He submits that the pension papers will be prepared without any unnecessary delay. The paragraph. So, in view of the submissions made by the learned counsels, there remains nothing to be decided in this writ petition. Stop. The writ petition is closed by directing the respondent to prepare the pension papers, the petitioners, at the earliest without any unnecessary delay.
Lordship.
With the above, writ petition stand disposed of.
Obliged, my lords.
Item
Much
number
less, Lordship.
7.
My lord, here there are only state respondents, and we will be filing the affidavit in course of the day, my lord. I've already served the copy to my friend also.
My lord, I have received the copy yesterday evening. My only prayer, my lord, here, my lord, in the affidavit they have not annexed any
Anyway, affidavit has not come on
Yes,
record.
my lord. Yes,
My lord,
allow it
in
to come on
the
record
affidavit
first.
will come, my lord. We are arguing
Then-
based on the petitions document, my lord.
My only humble prayer, my lord, is to bring the records at least, my lord, the answer sheets, my lord. I have still.
Wait for the affidavit to come on record first.
My lord, yes.
They may change the affidavit. Isn't it? So long it is not filed, they have a
Correct,
right
my
to
lord.
change
Yes,
it.
correct, my lord.
They can change it and they can give you a fresh copy.
My
also.
only prayer that is. My
We'll see once the affidavit is on
Let the
record.
affidavit
Yes,
come on
ma'am.
board, my
Yes,
lord.
Okay, it's submitted by. At least you should know what submission to be made at what stage.
No, my lord, since he has made so.
Yes, Miss R. Colony Learned J. appearing for the state tribunal submits that the affidavit on behalf of the affidavit on behalf of the state would be filed during the
Course of the day, my lord.
in the course of the day. In the course of the day. Stop in view of the submission. This is matter after a week. Just file it and then just
My
go
lord.
through it and then just.
My lord, yes.
Please appear to present it.
Hello, bless.
Yes.
Lordship, with regard to respondent number 4, I have filed affidavit of service, Lordship.
And what does it say? Not served or served?
Served, Lordship, already.
How it is served? And when? And where?
Respondent number has received on 21st/7/2025, Lordship. Only have
Okay. So this is respondent number
4, Lordship.
4. And others 1, 2, 3 are represented by
State, Lordship.
the state. Is it correct?
Yes, Your Lordship.
Yes. Okay. The you don't say the. Well. Pursuant to the order of. Just don't say this thing. The Mr.
M.R. Marak, Lordship.
M.R. Marak.
Yes, Lordship.
Court is very poor in remembering name. Mr. M.R. Marak, Learned Counsel, appearing for the petitioner, submits that an affidavit of service in respect of respondent number 4 has been filed, showing the factum of delivery of notice upon him. Who is respondent number 4?
School Managing Committee, Lordship.
Factum showing the factum of upon, not upon him, just it's a managing committee, so it him will or her will do this thing. Has been filed. What is it? Just in video service showing the factum of delivery of notice upon the respondent number 4 has been filed. Stop. Over. However, there is no appearance on behalf of the respondent number 4 when the matter is called out. So what is to be done now? You will file affidavit.
File the affidavit, Your Lordship.
Yes. Then just say. Then say as paid for by MS Nagru, Learned G, appearing for the state respondent. How much time?
2 weeks' time.
2 weeks time is granted for filing affidavit. Yes.
Much obliged.
9.
Yes.
Please, Your Lordship. Lordship, I'm praying for some time to file my affidavit, Your Lordship.
Okay.
And for the petitioner, Your Lordship.
On prayer written by Mr. Pala, Learned G, appearing for the state respondent. How much?
2 weeks, Your Lordship.
2 weeks time. You do not take more than 2 weeks at a time, isn't it? That is the allotted quota. 2 weeks, 2 weeks, 2 weeks, isn't it? 2 weeks time is granted for filing affidavit in opposition. Yes.
Obliged, Your Lordship.
10.
state, we are for the state, my lord, 1 to 5. So we are awaiting instructions, my lord, in this matter.
I'm also querying for number 8. I require some more time to file my affidavit.
So none of the parties have filed affidavit.
No, lordship.
None of the parties, Your Lordship.
So we'll give them time.
Your Lordship.
How much time you need?
My lord, may I pray for 3 weeks, my lord?
Fresh matter, Lordship. 3 weeks can be granted.
So until and the matter becomes stale, no affidavit is to be filed, isn't it?
3 weeks, we'll try to file it, Lordship.
Yes, just one prayer made by the learned counsels appearing for the respondents. All prayer made by the learned counsel appearing for the respondent number 1 to 5. Comma 6 to 7 and respondent number 8. Miss Dakhar is appearing for 6 to 7. You will also file your affidavit. Okay. One prayer appearing for the learned counsel appearing resolution number 1 to 5, comma resolution number 6 and 7 and resolution number 8, comma 3 weeks time is granted for filing a respective affidavit in opposition.
All right.
Hearing item number 50.
Yes.
Okay.
Yes.
Lordship, I've informed sir. Just waiting, Lordship. My colleague has gone to call, sir.
Yes.
May please, your lordships. Also, this is the third round of litigation, my lord. The issue herein is, my lord, denial of promotion, my lord. I have been superseded by my juniors, my lord. And only on the basis of my status as a HIV positive, my lord.
Can it be ground?
Exactly, my lord. So that is the limited issue here, my lord. Initially, what had happened?
So they have filed an affidavit.
They have filed.
And which way they defend the saying? They say that.
That is the ground, my lord. That my shape has been, my lord, brought to shape 2. Shape 2, my lord.
So not on the, they do not say in their affidavit that you have been denied promotion because of.
Yes,
HIV
they say that.
Okay.
Now, my lord,
it means you have been put under low medical category.
Exactly, my lord.
Because of the HIV.
My lord. Now, my lord, on the first round of litigation, what had happened, my lord, before I come to the facts, my lord? My lord, I was serving as constable, ministerial, my lord. This is very important, my lord, ministerial, because I am not into
general duty.
Yes, my lord, general duty. So, my lord, post arose, my lord, vacancy, post of head constable, my lord, at Taligudi, Siliguri. Initially, I was posted at Manipur, my lord. Now, what had happened, my lord?
This concerns Assam rivals. No.
My lord, BSF.
BSF.
So, my lord, what had happened, my lord? I applied for that post
Now,
as
if you are posted in Siliguri, why the case is here?
No, my lord, this is the third round of litigation. So, what the genesis, my lord, I am coming. Now, my lord, I applied for the post of head constable, my lord. Thereafter, my lord, I got qualified. I was selected as a departmental candidate. So, a technical resignation was, my lord, submitted at my parental this thing, my lord.
Just a minute, just please, court has not followed it. You were employed somewhere.
In Manipur.
Manipur. In which department?
BSF only.
And then where thereafter?
Vacancy arose in BSF itself.
Okay.
But the post was for Taligudi, Siliguri, my lord, Bengal.
So then you have taken part in a fresh selection process?
Not as a departmental candidate.
Okay, so that is a promotional committee,
my lord.
something like that?
No, my lord.
It was not a fresh recruitment?
Fresh recruitment, and there were some, my lord, reservations for the departmental candidates also, my lord. So, my lord, I appeared as a departmental candidate.
No, it was not a continuation of your earlier appointment. It is a fresh appointment.
My lord.
Correct, because this is very important to understand.
Yes, my lord. My lord is absolutely correct, my lord. I got selected, my lord.
Okay.
So I submitted my technical resignation at my mother headquarters, my lord. So I proceeded for Shiripur.
You resigned from the post of constable in Manipur.
My
Yes, sir. And
my
then proceeded to join your new post in
Taliguri, that is Bengal.
in the post of
Head constable.
head constable. Okay.
So, my lord, surprisingly, my lord.
One second.
My lord.
This court is not very acquainted with the service rule, so there may be so many questions.
My
So you may feel sometimes also annoyed also because of so many questions.
No, my lord. That will be a learning.
Head constable is a promotional post, or
yes, promotional post.
So it cannot be filled up by direct recruitment.
My lord, there were, my lord, advertisement. Certain number of posts were for direct entry, my lord, and for.
But court is not getting the reply. Reply is this: head constable, whether it's a promotional post.
Promotional
or
post.
Promotional post. Now, if it's a promotional post, how can there be a direct appointment of yours, wherein you resign from your previous job and join it?
Exactly, my lord. Because, my lord, what had happened, departmental candidates were, my lord, allowed to sit for that.
Can you see the advertisement by virtue of which you have joined this?
Yes.
Siliguri thing.
No, I'll show it, my lord.
But the appointment order is there, my lord, in my affidavit.
Appointment order is there.
See, until and unless the court is properly briefed about the fact, there will be wrong application of mind. Now, it's very much, since it's a promotional case of promotion, so it is very much, required to understand the nature of appointment.
My lord, his second appointment, my lord, the first fact is, my lord, in 2001 he joined as constable, my lord, as a constable.
In Manipur?
My lord, in BSF, my lord. Place is not important, my lord. He joined BSF as constable in 2001, my lord. Then,
if the place is not important, that will not be disclosed. Anyway, whatever it is, yes.
Now, my lord, if lordship kindly comes to my affidavit, my lord.
Just tell us the fact. Mr. Gurung is yet to commence his argument. We want to get the clear fact.
Just to clarify this fact only, my lord.
Without your assertion or this assertion, the admitted position, so far as the fact is concerned. There is no details of your appointment in the petition.
It is there.
Have you given? Oh, you can go through your petition and you can understand that.
Page 15 of my affidavit is there.
What will be better, to go through his affidavit, his petition, or your affidavit? Which gives a more clearer picture?
I think my affidavit will give more clear picture. All the documents are in.
Is it correct?
But only the documents. I'll not go to the pleadings. So
definitely, there is no question of
pleading. I'll reply.
Without painting those documents by your own paint, isn't it? Without painting those documents with your own color.
Yes.
Just yes.
As the document is, my lord.
Yes. Which part shall we see your affidavit?
Page 15, my lord, of my affidavit.
Page 15.
1-5, my lord. Lecture 1.
Yes.
This is the order dated 23rd March 2012, my lord.
First appointment.
This is second appointment.
Second.
Where is the first appointment?
First appointment.
This is there any connection with the first appointment so far as your present claim before this court is concerned?
No.
The first appointment has nothing to do.
Nothing to do.
Okay.
Nor the second.
Even second also has no connection.
Not important.
Then how many times you have been appointed?
My lord, twice I have been appointed. First as a constable, thereafter as a head constable.
With
now
the post of constable you resign, you join the post of head constable. Then what happens?
Now, my lord, I am entitled for my promotion as a assistant sub-inspector.
Okay.
Now,
it lays down some qualifying service.
My lord. My juniors, my lord, they have been given the promotion, my lord. I am denied solely on the ground of my status, HIV status. Now, on the earlier round of litigation also, my lord, what had happened, my lord, when I got appointment as head constable, my lord, there also, my lord, no works was, my lord, endorsed to me as a head constable surprisingly for 6 months. Thereafter, I inquired why I have not been given my lord, work. Then a medical test is conducted at that point of time. Suddenly, for the first time, they come up with a, my lord, result that I am HIV positive. Consequent to which, my lord, I have been advised, now your appointment as head constable is cancelled. Go back to your mother department, headquarter, and join as constable, my lord. So challenging that, my lord, on the first round of litigation, my lord, I was before your lordship, my lord. Now thereafter, the same was disposed on the ground.
You were successful in challenge,
my lord.
So,
and therefore, my lord, in compliance with that earlier order, my lord, I was given the post of head constable. At that point of time also, because of my HIV status, my lord, my medical category was brought down to shape 2, my lord. Shape 2, which is wrong, my lord. Now here also, why I am not being promoted, my lord, the same, I am in shape 2 enhanced. That cannot be.
So the ground is not specifically HIV positive. Ground is low medical category.
Because of my status as HIV.
That is you are saying, but then we have to see what the document is.
Now that is the, my lord, facts of the case, my lord, here. Okay. It is not disputed that I have been superseded by my juniors, my lord. Now they are waiting for another promotion, my lord. Whereas I have been, my lord, kept that way. So, in this regard, my lord.
Have you made your juniors party in this writ petition?
No, my lord.
Not required.
They won't be affected, my lord. They are promoted.
If you are directed to be promoted, will it not that it will restore your seniority over them?
Yes, yes.
If you say juniors are promoted, then definitely you will again become senior to them.
Yes.
So that will definitely have a bearing on them.
My lord, so far my understanding, my lord, the juniors have been promoted, my lord, and they are serving as assistant sub-inspector right now, my lord. And my claim over my promotion, my lord, once it is successful, my lord, my presumption is that, my lord, they won't be affected in the sense, my lord, it is admitted fact, I am senior to them, my lord. And the department has also, my lord, is silent on that. Rather, it is an admitted fact, my lord.
Anyway, we do not know. Your submission is basically confined to what you think. But then legally, it cannot, you see. According to you, admittedly, they may be junior. But then the fact remains, they have continued in a higher post. But sometimes, before you get in there. So, will it not have any bearing on them? Anyway, leaving the set. So, this non-joinder of party has not been made an issue in this state petition. No challenge.
No.
They have not come with that.
No.
Okay.
So, my lord,
what is just first take us to the law, which basically says that you should be promoted. Where is the law which guides the rule which speaks about?
I have got, my lord. Now, before that, my lord, my promotion, my lord, firstly, my lord, I am a ministerial candidate, my lord. So, there is a distinction, my lord, shape 1 and shape 2, the medical category, my lord. Shape 1 is for those combatized, my lord, those personals who are serving in the active duty. So, my post is ministerial, clerical work, my lord. So, shape 1 is not required for that, my lord.
And this work is not interchangeable. They say like a person.
No. My initial appointment is, my lord, ministerial.
So those who are in the ministerial thing, they will remain forever.
My lord.
They cannot be deported to general duties.
No, my lord. So, my lord, here, my lord, because my limited submission is that, my lord, my status as a HIV positive, my lord, person, my promotion is denied solely on that ground, my lord, which cannot be done under the law.
You just take us to those relevant documents. Where is your claim of promotion? Where is the denial of that? Just show us all those. First of all, you just show when you came to be appointed as head constable. What is the qualifying service? What are the process to be gone through for promotion? And what can be the disadvantage? And what may disqualify you from getting promoted?
My lord will come to, please have Annex 01 at page 25, my lord.
Mr. Gurung, have you annexed the order passed by in the earlier round of litigation?
No, my lord, it is not.
Why you have not annexed it?
It is here, my lord. Kindly come to page 36, Annex 2. The same issue here, my lord. If I may read, my lord.
Anyway, just proceed the way you do it.
I'll read this, my lord. The page 36, my lord.
No, but then this
will, my lord, reading
earlier round of litigation also dealt with the issue of HIV. Is it
same thing, my lord. So, meaning thereby, my lord,
what was the finding recorded there in the earlier round of litigation?
Finding recorded that because of my status as HIV, my lord, I cannot be denied, my lord.
Is it? And
Appointment.
then that order was challenged. Was it challenged?
No, my lord, it was complied. But just that, my lord, what had happened while complying with that order, my lord, of this honorable court, my seniority was not calculated properly, my lord. So another round of litigation was there, my lord. Thereafter, the court.
Hold for a minute. Just let us just go through.
I can.
Please come to page 40, paragraph 7 of the observation of this High Court.
Yes. Paragraph, my lord.
Yes.
7
at page 40 of your writ petition.
After considering the submissions advanced by the learned counsel, it is clear that petitioner was found otherwise fit for the post of head constable, but he has been denied to join the said post just because he was found to be suffering from HIV P2. It is also apparent from the submission of the learned counsel for the respondent that unless a person reaches the stage of P5, he cannot be dismissed from service.
Okay.
Since in the instant case the petitioner is only at the stage of HIV P2, but otherwise fit to serve, hence I do not see any reason that he should be deprived or discriminated only on the ground that he is suffering from HIV P2. Further, if he is deprived or discriminated, definitely the right of the petitioner as vested under Article 14 and 16 of the Constitution of India is infringed, and such discrimination is not encourageable at all. Furthermore, we should also understand that a person suffering from HIV needs more care and support from the society, and he to be treated with compassion and understanding. Accordingly, the impugned order dated 15/11/12 is hereby set aside, and the respondent is directed to allow the petitioner to join the post of head constable, for which he has been selected within a period of 1 month from the date of receipt of this order, and he to be treated with compassion and understanding. Before I part with this case record, I observe that the name of the petitioner. So, my lord.
Now see, this finding remains. It has not been interfered with, isn't it? Now that shows that so far as we go with this judgment, that means your medical categorization as HIV P2 should not be used to
Exactly.
You see, discriminate you against others.
Exactly. And that is the issue here.
Now that is the position we should stand.
Exactly.
Now, here you say the denial of promotion, the further promotion, is only because of
Yes.
HIV P2.
Yes, my lord. Nothing else.
Nothing else.
No. Now,
Yes. If that be the thing, yes, Dr. Mojika.
And here what happened, my lord, when he was detected with HIV, he was placed in P2, my lord. This honorable court said that unless, until somebody reaches P5, my lord, he cannot be dismissed from service. So as long as, because P2, P3, there is a category, my lord. P5 is the last category when he is unfit to serve anymore. So he has to be removed. So this honorable court said, because he is still in P2, he has not reached P5. So what cannot be a ground for dismissal from service cannot be ground not to allow him to join the service. We're clear on that one.
Read the words. What he says. He should not be deprived or discriminated. No, that is what. That word matters.
My lord.
Yes.
Now for the purpose of promotion, my lord, promotion have different criteria. Dismissing from service is one criteria, my lord. Dismissal can be only if he reaches the last stage, my lord.
The earlier draft of writ petition, was it against your dismissal from service?
No, my lord.
Yes, from removal from service.
No, my lord. Denial of my appointment.
Denial of joining.
Whatever the thing,
But
then there is a categorical finding by this court that he cannot be discriminated. So if you say that cannot be discriminated, that means he should be treated at par with others.
Yes, my lord.
His counterparts. Yes.
But may I read page 40 once again, my lord, para 7.
Yes, please.
After considering the submissions advanced by the learned counsel, it is clear that the petitioner was found otherwise fit for the post of head constable ministerial, but he was not. He has been denied to join the said post just because he found to be suffering from HIV P2. He was at P2 stage, my lord. It is also apparent from the submission of the learned counsel for the respondent that unless a person reaches the state of HIV P5, he cannot be dismissed from service.
You can understand. Yes, proceed.
Since in the instant case the petitioner is only at the stage of HIV P2, but otherwise fit to serve, hence I do not see any reason that he should be deprived or discriminated only on the ground that he is suffering from HIV P2. Further, he is deprived or discriminated, definitely the right of petitioner is vested, so and so. So, my lord, what this honorable court said, that he is only at P2 level, he has not reached P5 level. So, he is still fit to serve. But once he reaches P5, if he was P5, department could have asked him not to join. Because P5 is unfit to
That
serve.
is the only ground when so far as the medical ground is concerned, that is the only stage when you can dismiss him from.
Because he was only P2, so he should be allowed to join. He was allowed to join, my lord. Now, when it comes to promotion, my lord, promotion requires SEP 1. The criteria are different for dismissal and for promotion.
Just show us what is the criteria for promotion.
My lord.
What is your post, next promotional post?
ASI.
Your claim is for promotion is to what post?
ASI, my lord. Assistant Sub Inspector.
Well, if I may take your lordship to page 49, my lord. Starting from page 47.
Just a minute. Of
my affidavit, my lord, sorry.
There is a post of this thing, ASI ministerial also.
My lord.
There is a post.
So, the promotion in the ministerial cadre are made from the ministerial post only.
Yes.
It is not otherwise.
No, my lord.
And so far the condition of promotion is concerned, whether it is same for GD and ministerial.
Is same one, my lord. Is all same.
You please do not respond. When you are represented by your counsel, it goes against that account of the court. Kindly. Yes. Yes. Page?
Page 49 of my affidavit.
Yes.
Well, I'll take a lordship to page 14. This starts from page 47, my lord, this letter. But I'll just read para at page 49, my lord, sub-para 2.
Yes, just to show the medical categorization.
His medical categorization.
Yes.
Officer, men who are wounded, injured during field firing, accidental firing, explosion of mines and other explosive devices, and due to accidents while on active government duty in India or abroad will be eligible for promotion in the following subcategories. Since the petitioner was placed under LMC
Dr. Dr. Majika, this is only an communication.
Yes, ma'am.
Where is the rule guiding promotion?
Rules are not.
We want to see the rule. There may be several clarifications like this issued from time to time.
You know the rules. Well, the medical categorization rules today I don't have. But again, tomorrow will.
That appears to be vital. You have to show.
I'll place it. That same one is required, my lord.
We still have 10 minutes more to go for lunch break. So you can just proceed further. We'll definitely continue it
Yes.
the next day.
My lord, our case, my lord, I'll support that with the rules and the guidelines, my lord. Our case is, my lord, for dismissal of service, the criteria is different, my lord. For that, he has to be unfit to be in service at all. When he is found that he is not in a position to serve, then he can be dismissed.
See, sum and substance of your submission, what you have said just now, till now, is basically that earlier cases with regard to something, you say like is a dismissal from service.
My lord.
He was not allowed to be retained in some ways.
My lord.
So at that situation, he approached the court. And court said that yes. Since he has not reached medical categorization stage 5, and it's an admitted case, that it's not a...
So even now he's not 5, he's now also he's in 3.
Now what we need to see is that for promotion in the ministerial category, whether categorization under shape 2 is a bar or not.
Exactly, my lord.
Yeah. And which way...
If I satisfy your lordship only on that for promotion he has to be SAP 1.
And this...
Because he is in SAP 3, my lord, now, P3.
And the observation made by this court at the early end of litigation is confined only to the facts and situation of that case. It is not to be carried forward for future consideration.
So, my lord, our case is that he can continue in service till he reaches P5.
So that means...
But he cannot ask for promotion.
That means all HIV person in the service...
It will affect their promotion, my lord.
Will not get promotion.
It will affect their promotion.
Now, what happens to a person...
Because his functionality...
Who is promoted and subsequently diagnosed of having HIV?
Then he will remain there, my lord. Once he gets a promotion...
He will not be demoted back.
He will not be demoted.
My lord, there are, my lord, several Supreme Court judgments, High Court judgments, even the, my lord, rules were, my lord, satisfied.
Where there is specific provision, that has been...
My lord.
You have to come with this. If that is your contention, you have to...
I have got, my lord. I am ready with it.
So you are waiting for
exactly,
him to finish. And thereafter drop your bomb.
Continue tomorrow or Monday.
Tomorrow, Monday, we do not know. We will continue.
But any day.
Tomorrow it is not possible when you know.
Oh,
that
tomorrow.
Station.
We'll have it after a week, man.
After a week, possible. Okay. I'd landed counsel for the parties. On prayer, mate. This is a matter after 1 week. After a week. For any. Please come with that medical category. Let us not go travel here there. Just come to the crux of the issue.
That is the crux of the matter.
It's useless if
Yes, ma'am.
to travel to the other.
I'll place that.
Also, this court also doesn't have that much patience to see.
Well, I should have
around the
but
bush,
somehow
you
I
see.
missed it because one set of rules is there in which goes in different files. My lord. Today is not there the file. It's quite bulky, so I printed only one set.
The court is yet to overcome its initial habit, the
My lord,
previous habit.
Even if it exists in the rules, my lord, that has been set aside, my lord, in number of cases, my lord. When there is a discrimination to the HIV.
Very good. If there are such things, definitely we'll just.
Yes.
But then give us something which would be relevant.
Exactly, my lord. I'll try my best.
Just not to satisfy your client that you have performed. Just it would be. Yes.
Obliged.
Deeply obliged.